Thank you very much for having me in this very important discussion on the final draft constitution of the Gambia. My very short intervention is based on my combined readings of the final draft constitution, the report, as well as the explanatory note prepared by the Constitutional Review Commission. Generally, I think there is a consensus that compared to the 1965, 1970, and the 1997 constitutions, the 2020 final draft constitution is definitely miles ahead. As read from the draft, it seeks to reshape the institutions of the modern Gambian state, entrench public freedoms and rights, create a real separation of powers, and establish effective checks and balances. However, needless to say, there is nothing like a perfect constitution, and I have read and sure others have seen that there has been some sort of criticism that the 2020 final draft constitution is plagiarized from the 2010 Kenyan constitution. In my very humble view, I do not believe this to be true. This is because I think there is a gradual recognition that globalization is changing the contours of law and how we create new legal institutions and norms. The new draft constitution, if you compare it, say, to the Kenyan constitution, the Zimbabwean constitutions, and other African countries that have drafted or adopted constitutions in the recent past, have actually modeled their constitutions on other constitutions in Africa and around the world. And ours, you can say, is particularly modeled on the Kenyan constitution, which I believe is not a bad thing. This is because I believe a willingness to look comparatively should not be an impediment to us developing and maintaining distinctive legal approaches that respond to our particular history, values, and needs of our nation. And definitely comparative research is generally valuable. In terms of major highlights for me, unlike the 1997 Constitution, the draft final Constitution makes some key developments. For instance, in Chapter 2, it makes it clear that treaties to which the Gambia becomes a party to will form part and parcel of the laws of the Gambia after they've been ratified and domesticated. But more importantly, it further gives the courts the discretion to use international treaties on human rights, to which the Gambia is a party to, as an aid to interpretation or application of any of the provisions on fundamental human rights. This chapter also makes new and key development to constitutionalism in the Gambia in terms of introducing broad rules on legal standing and enforcing the provisions of the Constitution. Given my background, I have to say a little bit about the fundamental rights chapter, which I believe is quite a milestone and is stipulated in stronger language than previous constitutions. The chapter generally provides for the enforcement of civil and political rights, as well as economic, social, and cultural rights. In particular, economic, social, and cultural rights that are currently provided for in the 1997 Constitution as directive principles of state policy are now made justiciable in this chapter. More importantly, also, the draft also includes a limitation clause under Section 36, which states that rights may be limited by a law of general application that is reasonable and justifiable in an open and democratic society based on dignity, freedom, and equality. However, the provision further goes on to set out the factors that must be taken into account when deciding if a limitation on a right is constitutional or not. In terms of the rule of law and good governance systems, the draft constitution also includes necessary governance institutions and checks and balances for the legislature, executive, and judiciary. By extension to this, the draft in Schedule 4 provides for the establishment of a commission for implementation of the Constitution, which is very important because, as noted elsewhere, constitution making is a long-term process leading to implementation of a constitution that functions the way it was meant to be, and definitely having a commission for the implementation of the Constitution forms a key part of this. With regard to the structural design of the presidency, I'm sure the other distinguished panelists will talk about that. But we know that in the final draft, the president shall not serve for more than 2 terms, which is important given the context that we're coming from within the Gambia. Also, there are new qualifications in terms of running for the presidency, which has also been introduced, such as educational work experience. Just to quickly talk about some of the shortcomings of the draft. We know that in this process of constitution making, the role of religion has been a point of contention. The prominence given to the majority Muslim community is evident with the Sharia courts sort of taking the center stage. One of the aspects for me that I continue to find problematic is how Sharia law is compatible with the equality provisions in the Constitution, especially as evident in the 1997 Constitution, and the disproportionate impact that this has on women's rights, especially considering the fact that more than half of the population is made of women. We also know that other contentious issues, such as same-sex relations, will be completely sidelined, as evident in the final draft. To quickly conclude, I believe that although the final draft has its, shortcomings and all of that, nonetheless, it is in most respects a very progressive document. A constitution is definitely the most important piece of legislation that we can have as a country. And ideally, it should reflect not only the history of the nation, but also, in my view, most importantly, it must mirror the interests and aspirations of its people, regard to how they wish to be governed. Thank you.